So as we have seen the qualification which one need to become a judge of the Supreme Court. So in initial year, mostly if you see Article 124 clause 3, which talks about the qualification, its sub clause 1 was mostly used, meaning hereby that judges of the High Court was elevated as the judges of the Supreme Court. Now initially the Home Minister Govind Vallabh Pant, he did talked about that the appointment of the judges to the Supreme Court shall also has to be made taking into consideration subclause 2 and subclause 3 of Article 124 clause 3. But if you see one of the instances when Advocate General of Bombay HMCY and Advocate General of Bihar Lal Narayan Sinha was asked by the Chief Justice H.R. Das, or rather H.R. Das offered him a position of judgeship in a Supreme Court, they declined this position. Although with the passage of time, if you see that S.M. Sikri became the first, you can say, Advocate General who was elevated as a judge of the Supreme Court of India. Now this was the pre-1970 period dominated by the Chief Justice of India in case of appointment of the Supreme Court. Although the appointment has to be made, as we have seen in article, in consultation with President, and President's satisfaction, we have seen that it is not his personal satisfaction, rather it is a satisfaction of the government. So initially if you see the whole prior to 1970 period, there was a too much of dominance of Chief Justice of India in case of appointment of the judges to the Supreme Court. Now if you see the post 1970 period, there was a bit shift in attitude. The shift in attitude was related to the aspect of the judges were divided on the basis of progressive judges and conservative judges. For an example, Justice Krishna Iyer, judges like Justice Bhagwati were termed as progressive judges, as they were behind judicial activism and public interest litigation. And there were other judges who were termed as conservative judges. And if you see specifically the 1970 period, there was a great shift, because in this period we saw a judicial verdict in a Keshwanand Bharti case which led to the judicial emergency in this country. And later on we know finally the national emergency was imposed. Judicial emergency, as I have told you in my earlier lectures, that what is a judicial emergency. So the post 1970 period gave birth to a system called a collegium system. Now there are 4 cases which we have to read in the collegium system, which I will take for